Who's on the phone? Is there anyone on the phone? If so, just speak up, okay? Thank you.
Okay, we're back. They still haven't had the Lane Myers hearing as of yet. I just had to try to take that little icon off, but I couldn't figure out how,
Morning,
so
sir.
I just moved my camera. Stay tuned. Hopefully we'll get to hear the Lane Myers hearing. Thanks for watching.
Counsel, just let me know when you're ready. You ready?
You need the mic.
Yeah.
No, you can just move
Just
the mic.
move it, yeah. State of Arizona versus Lane Myers, CR 2025-1060 and 2025-1454. Parties announce.
Rachel Stiles for the state, and Your Honor, the victim is present in the courtroom.
William Parvin on the second case number. I think it ends in 1454. I represent Mr. Myers. He's in custody. And Mr. Myers, you're not your parents for the first case number where you represent yourself.
Okay, and serving as counsel for representing himself in 1060. Mr. Myers, my name is Scott McDonald. I am covering this hearing for Judge Metcalf. I assume we're here to set trial and any other hearings that need to be set. So with that, what are the parties thinking?
Your Honor, for trial setting, we're looking at July 21st. That works with the victim. It sounds like that works for Mr. Parvin's schedule. That works for my schedule. So that's when we'd like to set it for 5 days.
Let me just make sure that works.
July 21st, right?
It does. All right.
Do I get any say in that?
You represent yourself in 1060, so yes, sir.
That doesn't work for me.
Okay. What are you proposing, sir?
Next week.
So,
How about 30 days from now?
We've got to hear this motion first to dismiss the case.
All right, so like 25 days from now. So that 35 days, because that'll give me 20 days before trial. And
Mr. Myers, let me just ask you, because the state is trying to have these two cases, they're going to be consolidated. Is that?
We're going to put in a motion. I want to make sure that Mr. Myers has time to look at that, and that way if he has any objection to it once he looks into it. So that'll be addressed at a different time.
Talking about the motion to consolidate?
So, one moment at a time, okay?
So right now we can just set the 1060 trial, and then if the other one's consolidated into it, then that'll be at the same time. And that is within the speedy trial time. The speedy trial time's not till August. This is the case management conference.
Okay.
The pre-trial conference so we could set trial right away.
We're sitting on both, aren't we? Because I'm ready to set it for trial the same date on the one I'm still representing him on.
They're not consolidated yet, so we can't set them yet. But if they get consolidated, then they will happen at the same time.
Okay. As long as we're not waiving any
Can
relief.
you set another pretrial?
Hold on, we'll get to that.
Hold on, Mr. Myers. One at a time, okay? So let me just kind of understand. So Mr. Myers is asking to set trial sooner than the July, I apologize, 21st date. Do you have any availability? I know you were in trial, I believe the next 2 weeks, but do you have availability sooner? And I'm going to go through. So looking at that would be about, let me ask Mr. Parvin, giving your motion, what do you think a reasonable time frame to hear that?
On the other case.
No, Your Honor, may I explain? This is
Sure.
a little tricky. Mr. Myers wants to represent himself on one case and has his ideas and certain motions. Because he picked up a second case, he was non-bondable. At least says, now I'm working on that. I was assigned the second case, and there has not yet been a Ferretta motion where Mr. Myers can choose to represent himself. That's a silver lining because it allowed me time to file motions I think are appropriate. I talked to Mr. Myers about that. I filed a very strong motion dismissed on vagueness and challenging the statute that's never been challenged before under the new law. I would like that to be heard. I believe it may be dispositive, or there may not be a trial, or if there is, it'd be on a lot less charges. That needs to be heard first. Now, I know Mr. Myers wants a trial, but I strongly recommend he join in my motion and that we hear that first. And the July trial date is still within the 150-day time period. It's not violating any speedy trial rights. It works for my schedule, works for apparently the state schedule. That means if it turns out it doesn't work for the state schedule, the case is going to get dismissed because your rule 8 would be violated. So they're vowing they're ready that day. They better be ready.
So,
But the point is that right now they're not consolidated. I'm sitting in jail with no bond.
okay.
I don't have access to any way to prepare for my case. So sitting in jail is a complete waste of time because I'm going to get a new trial for not being able to prepare for my case. So the faster we have this trial, faster we can have the next trial and the next trial and the next trial and the next trial. Now, so it's actually worse for the state to have it. The longer I sit in jail, that's more arguments for me to not have be able to effective. So all they're doing is creating more prejudice against me the longer I sit there. So the faster we have the trial, the less that I can, we get through the first wasted time trial and get to the second trial, maybe third trial, fourth trial, however many trials we need to have, where I can effectively represent myself and put forth a case, because the Court of Appeals is going to throw out any convictions that are in this trial because I have access to no material. They've committed Brady violations, and they perjured themselves under the grand jury. And so, yes, I need a little bit of time to file the 12.9. I realize that'll stop the time for a few, but it is also probably going to get the case dismissed because they lied to the grand jury. And now I'm going to file a Brady motion, and I'm going to file actually a Rule 16 motion to dismiss. I'm going to file to dismiss, or in the alternative to remand under 12.9 for their failing to provide exculpatory evidence and the detective perjuring himself in the grand jury. And then I'm going to file another motion to dismiss because they're violating under State versus Warner, because they're violating attorney-client privilege, and I have no way to have a privileged communication in the jail. They've invaded my work product, and I want to. So you're going to have to set a hearing on the Warner motion, because under the state, it requires an evidentiary hearing for me to be able to prove the prejudice when I have them literally within an hour of me having a communication with my lawyer. They're doing things to counter my argument. So I've already effectively caught them in a trap of violating attorney-client privilege, violating work product, and I'm not getting a fair trial. So as soon as I file that motion, there's going to need to be an evidentiary. So there's going to be 3 possible reasons to have it dismissed. Or it's either going to be dismissed under 12.9 or remanded. 16, it's going to be dismissed for it's insufficient as a matter of law. And on the State versus Warner, the holdings are the controlling case law in State versus Warner is going to say that you have to set an evidentiary hearing, and then that shifts the burden to the state to prove that they weren't violating my thing when I got it all right here to prove that they've went through my work. I have no way of effectively preparing a case in custody, because they know everything I'm talking about. They know everything that I want, any case law I want, any communications that I say, hey, help me get this legal document. First of all, how am I going to get work product off my computer at home? How am I going to get my disclosure that I'm required? So I'm going to be in violation of Rule 15.2 because I can't even give them the disclosure that I want to give them because it's at home on my computer. So I have no way of getting it. And if I call
Mr. Myers, do you mind slowing down? Ellen here is taking down everything. Thank you.
If I try to contact people outside of the jail, either through the text on the tablet or by phone, to say, hey, I need this or I need that to perform my case, well, they're listening, and I've already caught them in 3 traps listening to my work product. And I'm telling you, under State versus Warner, the burden is going to shift to them. They're not going to be able to do it, and the case is going to have to be dismissed because I'm suffering extreme prejudice because I cannot prepare a defense if they know everything I'm going to say at trial before I say it. You're supposed to represent, you're supposed to preside over a fair trial. Well, there's anything but fair going on here. They're literally invading my work product. And so under State versus Warner, it's clear all the way up to the 9th Circuit, the case is going to have to be dismissed. And if it isn't, the circuit court, or the Court of Appeals is going to dismiss it, because there's no way they can say they didn't invade my work product when I got them caught red-handed right here in front of me. And that's what I was supposed to discuss today, so that I don't know how you're saying, set other hearings. Well, I'm going to need an evidentiary hearing on the Warner motion. I'm going to need I don't know if they do an evidentiary hearing for the 12.9, but they probably would because it's going to be a motion to dismiss, because I was denied a substantial procedural right of having the fair and impartial evidence and exculpatory evidence being presented to the grand jury. So that's actually dismissal reasons, and in the alternative, remand. And then on top of that, I'm going to file the Rule 16, so I don't know if he's going to want to have a hearing on the Rule 16 motion to dismiss as insufficient as a matter of law. But all that stuff, I only need to file that 20 days before trial. So sitting in jail, waiting for till July is a complete waste of time. I'm suffering extreme prejudice. There's no way I can sit in jail and prepare my case when they're listening to everything I'm doing. And furthermore, they're going to be able to hold it against me that I didn't give them their disclosure. So it's not even ever going to be a fair trial because I have no way of getting my evidence from my house to the court. I have no way of getting my Rule 15, the disclosure, the exculpatory evidence I want to present. I have no way of contacting witnesses from jail. What am I going to do? Contact my witnesses and have them come to the jail? The jail's just going to let random people come in the jail and let me interview them? No. The jail's already denying me the law library. They said they don't care what the judge says. The judge doesn't control the jail. Rachel promised the judge that she was going to make sure that I got access to the law library. And let me see here. So is this everything? Rachel, where's my witness list that was due yesterday? Rule 15 disclosure was due yesterday. They failed to meet their obligation. I already had a motion to compel. Judge Metcalf said we had to wait for the 30 days. The 30 days expired yesterday. I don't see the Rule 15 disclosure in front of me. You got it? Did they give you the witness list?
So,
Law disclosure, I don't think I have a witness list.
Well, the witness list was due yesterday, so now I'm going to move to exclude anybody on their witness list as a sanction because it was due yesterday.
Okay.
And the judge made it very clear, Rachel, or Ms. Stiles, that you must provide the disclosure even if it's in jail. We don't want to hear the excuse about you gave it to Parvin. I see people get mail from the Pima County Attorney's Office every single day in jail. They haven't given me the rule. Where's the witness list? It was due yesterday. So if
Mr.
I don't have the witness list, they're in violation.
So just
Did they give it to you?
I don't think.
So exactly.
Mr. Myers, one quick thing,
Updated.
or a couple things, okay?
Yep.
So one, you said that the 12-9 motion, I can't give you legal advice, but hold on, that has to be filed sooner.
No,
than
we already
20
got an
days.
extension on that.
Okay.
I got
good.
it. Yeah, I already
All right.
asked. I immediately asked
Okay.
for an extension out to 60 days, and I'm gonna ask for that
Great.
in the. I want the case that because I'm gonna be once his motions are heard, then I'm gonna take over pro se, and I want that extended on that too.
Mr. Myers, here's what I'm gonna do. If you need to file 3 motions, okay?
I have no way of doing it at the jail, so
and
I'm putting it
get
on
an
the record.
evidentiary hearing, it's not enough time to set it in May, okay? I'm happy to look at May dates,
Okay,
but I'm
early
telling
June?
you. So I'm happy to look at if.
They got to convict. They got to
Can I
convince
respond?
12 people
Sure.
unanimously. to
One
convict
person
me.
at a time, please, for Ellen's sake, okay?
Yeah, I feel you.
All right, so Mr. Myers, I'm going to hear from Mr. Parvin, then Ms. Myers, or Ms.
I got a lot of stuff though,
I
still
know.
points of order for the pretrial. Like we're supposed to be discussing disclosure. I got some other things to put on the record here. That's happening.
Mr. Myers, I'm not your judge. I'm here just to set dates. If you want to just simply
It's
come
not.
back.
But the judge told me today I would be able to. He told me to come back and have. It's supposed to be a case management conference. It's supposed to be more than just setting dates. It's supposed to be me making,
Mr. Myers, let me
putting
talk.
stuff on the record, asking the judge to order things. So you can't order things.
I am not your judge. I'm not familiar with your
Doing
case.
today.
Let me talk a little bit.
Yes.
I've been in communication with Judge Metcalf's clerk and Ms. Stiles. We've arranged to have a Monday hearing at 4 o'clock, hopefully earlier if the restitution hearing that's going on is done sooner. That's going to be a bond rehearing motion that I filed notice of that. And all these issues that Mr. Myers brought up, I will address as his attorney of record on that case, although Mr. Myers, I believe, can have input if there, I don't know if both cases are heard that day or not. I suggest that the court order both case numbers set on that day. We can address then any hearings that need to be evidentiary hearings or Mr. Myers' concerns. I also feel I need to clarify for the record, the jail has never stopped me from going, unless there's a lockdown, which happens more often than it should. Generally, I can go there and talk to Mr. Myers in person. I've spent hours, sometimes an hour and a half, sometimes 2 hours, talking about motions and evidence with him in the jail privately. That's not recorded or anything like that. The issue
That's
is,
in that case.
again, or several, okay.
That's in that case.
On my
not in
case,
this
yes. The one I'm appointed on, I'm not just
1454.
advisory.
Yeah, right.
Yes.
Not my
There's
case.
been no issues. The issue is, since Mr. Myers is acting as his own attorney, he needs to, I guess, prepare defense. And since I'm not always available to spend hours at the jail in person, he needs to text other people or arrange to work on his case, and that's monitored on a daily basis. That's his problem.
Okay.
Again, I'm going to address that on Monday, and I think there are suppression motions that I could file on my end to deal with that, his concerns. But I'm just make it known to the court there hasn't been a problem stopping privileged communications. That's never been a problem.
I disagree.
And
Okay.
Can I just, I'm going to ask Mr. Parvin one question, and then I'll hear from Ms. Stiles. Mr. Parvin, from your perspective, I'm happy to simply continue the pretrial conference until Monday. I'm happy to set trial on July 21st, and if you want to accelerate it, whatever you want. So again, I am just filling in today. I apologize.
Well, I think we're within 150 days, and if I'm going to be doing the trial, I would like that July 21st.
He's not going to be doing the trial.
That gives me time to prepare on my end. I want to do a good job, and I want my motion dismissed heard. I believe it has a lot of merit. That's my concern. Mr. Myers, I need you to join in that motion. Can you please do that?
I will.
Can you orally do that today? Or you can join in my motion?
All right.
But I'm saying,
Has it
as
been
soon as
filed?
his motion,
Yes,
yeah,
it's been filed. I just need him to join on his, so therefore we can hear it on both case numbers.
you're talking about
My motion is dismissed. I just handed
right,
you.
the one. So it's going to
harassment.
apply to both case
It
numbers.
should, as long as you join in it.
Right. Okay. So I want to join that, and what I'm saying is all the motions got to be filed 20 days before trial, right? So my thing with Mr. Parvin is that once we hear his motions, and once the state argues to keep me in jail with no bond, it's all gas, no brakes. And so we don't need to waste taxpayer dollars, the court's time, the people's time, holding me in jail, wasting my time when I can't even prepare for the case. The faster we get to the case, the faster we get to the next trial, the next trial, the next trial. And so to me, what do we need to wait for July for? Nothing's going to change. The state has 30 days to give me they haven't even given me the evidence. What's going to change? They haven't done their diligence in this case yet. I've known these people for 9 months. I know how they work. I've had a judge give them 3 orders to give me disclosure, and they ignored it. And then they wait, and then on the 180th day, they dismiss the case. And so I'm not playing games. I'm sitting in jail with no bond for no crimes, and I don't have a way to prepare for the case. So you can't sit here and say that I'll be sitting in jail getting a fair chance to prepare for a trial and have a fair and impartial trial, because I'm extremely prejudiced being in jail, right? And so my thing is what does July do? It just lets them sit there and try to make me sweat, and then they're going to try to offer me some stupid plea bargain, and I'm going to laugh at them. And so
It guarantees you a
do you
trial
want me to
date.
set a
Here's the
hearing on
thing.
the motion to dismiss today?
Your Honor,
Can you do that?
he's saying that he wants.
Have your-
Hold on. Yes.
I wanted to
Mr.
clarify
Myers?
something about the trial. He said that in July it works for him.
Yes.
He's not going to be my lawyer for trial.
Understood.
Okay.
Thank you. Ms. Stiles.
Your Honor, in regards to the law library, the jail essentially they took where it was the law library was a place they went to. Now it's all electronic. It's on his tablet.
I don't have a tablet. That's incorrect.
He does. And so what happens is I confirmed with the jail, there's 1 tablet per 2 inmates. The same tablet he uses to do all his phone calls, his video visits, that is the same tablet that he has access to LexisNexis. The jail has a contract with LexisNexis that gives every inmate free access to LexisNexis. LexisNexis is, the competitor to Westlaw, so he has access to all the same things he would have had through Westlaw because he's familiar with Westlaw. He has been accessing that since March 21st. So we've been able to verify with the jail that he has been accessing the legal resources that are essentially the law library through his tablet and has been consistently since March 21st. Also, they have confirmed for me that, and I've filed a notice of this, they've confirmed for me that if he has any research that he finds on there that he wants printed, he just puts in a request with the law librarian and it'll be printed for him. That if he doesn't have pencils or paper and can't afford to buy it from commissary, he fills out a slip to say he's indigent, and then that will be provided to him. So the case law just requires for him to represent himself that he has access to the legal resources or that he has advisory counsel. In this case, he has both. So Mr. Parvin is law trained, and so he is able to also assist Mr. Myers with any research that he wants done. He's able to assist him with all the disclosure. Mr. Parvin has been getting all of the discovery. Everything has been sent to Mr. Parvin. All he has to do is he goes to the jail and then he has to play it.
Okay.
I know Mr. Parvin has not wanted to play, or sit there with him as much as he wants, but that's the requirement.
Ms. Stiles, what is so Judge Metcalf has a hearing Monday afternoon at 4 p.m. Is that correct?
So the judicial assistant has been scheduling that.
What is going to be heard at that date?
So there's one motion, it was the bond hearing, and then the other motion, they're looking at scheduling that Mr. Parvin has filed on multiplicity and then one on the constitutionality of the statute. I'm not sure that those are going to be set because one of them, we're also within the reply time, but I think that may be.
I get 3 days reply, but your response is due on Monday.
I know when my responses are due. And it's actually 5 days, Mr. Parvin.
So
But-
I'll leave it at,
The judicial assistant's already working.
hold on.
on it.
So with
Your Honor.
regards, hold on, please. Thank you. With regards to the motion to dismiss, can we calendar that today, or can we schedule that?
So I don't know, is that the,
So there's
One
a
other.
motion to dismiss in 1454. I believe Mr. Myers is intending to join that in 1060. So can we set that motion to dismiss for hearing in both matters?
so the judicial assistant's already scheduling all of them. And
Okay.
so I just don't want to get on top of what she's already doing as far as the scheduling.
I think we're in open court, so let's try to do it right now. So with regards to the motion to
Well-
dismiss, yes, I will, but, so it's been filed. Your response, we need, what, probably 20 days? Is that about right?
No,
I would think,
No, 10.
plus a reply,
it's,
plus time, a couple days for the judge to read it,
Can I
okay?
reply about the law library thing for a second?
I-
She just said that I have access to the tablet to read the
Sir,
statute.
hold
Reading
on.
the
Myers,
statute doesn't help
can
me
I
prepare for a
want to
case.
stay
I
on
need
one
to-
thing at a time.
this is why I suggest on Monday we do all calendaring that day
Okay.
at 4 o'clock. If
All
we
right.
have to, I think
That's
that's
fine.
best.
All right.
Because there's too much going on today. And
It is ordered setting a hearing in both matters on Monday. At that time, the court will set any hearing. Court will, for now, set trial in 2025 1454 on July 21st. Court
So-
will set trial in that matter. It'll be a 5-day trial.
Be 2025 1060 is the first one being set.
So I understand, but here's my concern is with regard to Mr. Myers asking to have a hearing or asking to have his trial sooner.
I can't hear you.
Okay. I'm only going to set trial in the 1454. There's no motion to consolidate. Mr. Myers is asking to have a trial earlier on Monday. Judge Metcalf can swap out those two trials, but for today, Mr. Myers is objecting to that, wants a trial sooner. Given, I'd like to hear, I haven't heard kind of a timeline to see about what it would take for Mr. Myers to file those 3 motions, have the state respond, set up oral argument, and then trial. So we'll come back here Monday at 4
Monday,
p.m.
4 p.m.
And court in
I'll
2025
be covering that
1454
one.
will set trial July 21st. If any party wishes to use a questionnaire, that they file a written request no later than 60 days before trial. With regards to that trial, it will be 5 days, 8 jurors, correct?
12.
It's depend.
12-man jury, unanimous only.
It's
So I'm facing more than 30
So,
years.
so
I
yes,
don't think
so with the,
Is it-
so not, so,
If both are consolidated, it would be,
yes.
so it will be a 12-person jury, okay?
Unanimous.
That's by that's by constitution,
I know.
sir. Okay, of course.
I'd like to reply about the law library because she just lied in open court.
All right, Mr. Myers, here's what I'm going to do. Your hearing's on Monday. I'm not your judge.
All right, so talk to
Okay.
him about it.
Correct, sir.
Thank you.
And
All
I have a
right.
concern, Your Honor. Mr. Myers has already said that he wants me to litigate this motion to dismiss I filed, but he wants me off the case after that. So, and he doesn't want that trial date. So I don't think the court should set a jury trial date. I think we should wait till Monday because Mr. Myers is currently objecting to that date as well and wants me off the case essentially.
All right, I've set a trial.
Aw.
He
Then
said
at that
so right
point,
now you are setting it on the only Monday.
that's correct. And then if that's the case, then Judge Metcalf can either set that in the 1060 or he can accelerate that to make sure that that trial can be heard sooner, okay?
Just
But
wanna make
only
sure-
under Rule 8, you
One
can only do
person.
that under extenuating circumstances.
you
We're
can advance
within-
it. That's about continuing.
Okay.
Yes.
It's not being continued.
Yes.
I just want to make sure that Mr. Myers has joined in my motion to dismiss, so when I litigate that, it'll be both cases.
The court will note that in CR
Thank you.
2025-1060, that Mr. Myers has joined the motion to dismiss in CR 2025-1454. That motion was filed on April 11th, 2025.
And the other 2 motions I filed do not relate to Mr. Myers. Well, so therefore, there's my motions. That's just the multiplicity. He doesn't need to join in those.
Okay, thank you.
Your Honor, at the last hearing, we discussed a settlement conference. I have tried to reach out to Mr. Parvin and talk to him about a settlement conference. Mr. Parvin has not been willing to engage in contacting the courts to get a settlement conference set. So I don't know where we're at with that because Mr. Myers is representing himself in one matter, but then Mr. Parvin. So I just want to be clear, is the state
Sure.
was willing to engage in that, but I can't do that if
Okay.
the defense
May I respond
doesn't.
to that?
Sure.
I asked for a plea. If the state wants to offer even a prison-only plea, then I'll request a settlement conference and talk about it. But I'm not going to just do nothing and not file motions and do my job and, where I had time to write motions. I had a available week where I spent almost every day working on the motions. I had a lighter schedule and I got it done. I'm not going to wait to see what may or may not happen at a settlement conference. What the state tells me, there's not going to be a plea and we have to talk about a settlement conference. Send me a plea and then I'll request a settlement conference. But if you're not going to set a plea, I don't see the point of it. That's just what I'm saying, Your Honor.
Okay, Mr. Myers.
And then in my, that's on that 154 or whatever, right? And I'm saying on the 1060, if she's going to argue that I should stay in jail with no bond, there's no plea bargains.
Okay.
Thank you.
All right. At this time, I'm not going to order. I mean, again, it's not my case, but I'm not going to order. I wouldn't order any party who's not willing to participate in a settlement conference, and I'm not going to order them to because I think it's meaningless. So.
Yeah, I just wanted to make clear that we were willing to engage in it. If they're not willing
Okay.
to engage in it, then there's no point in us
All right,
doing
and
so.
Mr. Parvin's
So-
saying.
We're willing. We want to make sure that we're willing,
Yeah.
but she
God
We
damn.
are willing to engage, but we'd like a plea first, even if it's a plea we don't like.
And-
That would at least have a starting point.
And Your Honor, I've made clear that we would engage in the discussions
Okay.
for a plea at a settlement conference. So it's kind of going to the settlement conference is what would.
Yeah.
So
But
if they want to engage in that, I'm happy to do so. If they
Sounds
don't
good.
want to, we don't need to.
Yeah, but the state asked me to hold off on filing motions until we had the settlement conference, and I can't do that because I had time to get them done when I did.
Don't file
I
motions.
got to file with my rule 12.9 and all that within a certain period, and it's going to
Why would they ask
delay
that?
the time and do all that kind of stuff.
That's weird.
Well, she don't get her cake and eat it too. She don't get to hold me in jail with no bond and then dangle pleas that don't exist over my head and then get mad when we make a T-shirt with her face and say that there's not going to be no plea bargains because we made a T-shirt with her face on it. She don't control it. A plea bargain has to be signed by me.
That's correct, sir.
That's right. So she can take her plea bargain back to her office.
Okay.
Your Honor.
So hold on. We're just going to come back here. So the next hearing will be Monday before Judge Metcalf at 4 p.m. It'll be 1
Monday,
hour.
4
Earlier,
o'clock.
hopefully.
Maybe earlier, but I'm not gonna. That's
Earlier?
not an order. Okay, so the order will
Okay.
come from in chambers. It sounds like there's
Mm.
discussion to make sure that it works for both your counsel.
Yes.
I'm gonna
Yes,
write
Ms.
that
Stiles.
down.
Well, that was what I just
Okay.
wanted to make clear
Sounds
is at
good.
the time that they were still working on it.
All right. So the
Let
exact
the
time.
record reflect. If she wants to send me a plea, I see inmates get pleas every day.
Okay.
I haven't received one.
Okay. You're right. I see that all the time.
Yeah, I know.
You have a good day,
I
Mr.
see them
Myers.
open their mail every day. They got a plea bargain from the Pima County Attorney Office.
Okay.
We're gonna go. Why would we go to a settlement conference that would waste the court's time when I might not even want their? So if I had like he's saying the same, right? We're in agreement here, right? He's saying send us a plea, we'll talk about it. I'm saying send me a plea, we'll talk. She hasn't even sent me the witness list, let alone a plea bargain.
All right.
Can you,
Thank
and can you order her to produce the witness list by 5 p.m. today, please? She's in violation of Rule 15 right now by not providing the witness list. So can you order her to provide that by 5 p.m. today?
So just to be clear, with regards to the witness list, do you know?
So it says on the initial disclosure that we send, it always indicates that the people that are within the disclosure are
That's not the law.
are
Hold on,
witnesses.
Mr. Myers.
I'm happy to send him a more specific
Okay.
list.
That's
Thank
He
you.
already
You
knows
mean
who
the
the people are.
witness
We've
list?
already discussed it.
Okay.
So
That's
a lie.
fine.
That's a lie.
With-
it's not.
Who's the witness?
Hold
Say it into
on.
the microphone.
I can tell
Counsel.
you right now.
Say it so I can go back
Monday?
and start working.
Detective Brown.
Monday, what time? So I'm asking, I just got a message from Judge Metcalf's JA. She wants me to do an order. So with regards to the hearing on Monday, what works for both counsel? And I'll just pull up the
Earlier
schedule.
the better.
Earlier
because
the better.
I don't think 4 o'clock's enough time to get this done.
Oh,
I would
that's
agree with you.
that's right.
Let me
Mhm.
look. Then
All right, so it's
it
gonna
would
be earlier now.
April
Shit.
21st. He has. (10:30 to noon).
April 21st.
Correct, sir.
That will not work for me. But again, I thought we were
April-
gonna I thought we were gonna do it on the 14th.
Oh, you,
No, April 14th.
Today's
the
14th.
14th
Oh, no,
is
sorry.
yesterday.
Yeah.
I'm thinking. Oh, wait, 21st. I thought we were doing
Yeah, this is the
the,
15th.
in the afternoon because I already had a juvenile case scheduled that's also getting all I've been told that has to be solved that day.
So can we
So
do-
there is something set from 4 to 5, but if you're asking for additional time, that's why I'm trying to find you something else.
Okay.
So-
No, I was told that we don't know how long that trial is going to go. They don't think it's going to take 3 hours, so we may be able to start earlier. So
Okay.
we can leave it at 4, but with the anticipation we're going to start right after that other
Sounds
trial.
good.
We,
That-
we can set
I
it
will
for
let them
3
know.
o'clock, and then if they're running late,
All right.
we'll just be
It is
here.
ordered that it be, Let me just look at one thing.
Excuse me.
That is the only case I can't continue. Sorry.
I'm just looking, so he has a restitution hearing at 2 o'clock. I don't know how long it's going. I can't imagine it's an AG case, but an hour would seem to be realistic. So I can set this for 3 o'clock, but there may be some overlap.
Yes, and
Okay.
that's fine. I'm happy to wait.
Court will set a hearing in CR 2025 as to the motion regarding bond. Additionally, the court will set a pretrial conference in both. Court will set a, in the 1454. Court will set a status conference regarding trial, and in the 2025 1060, the court will set a pretrial conference. So court will look to set trial in the 1060, discuss the trial date in the 1454, schedule any hearings on pending motions or motions that parties anticipate will be filed, and address the arguments regarding rehearing on bond. Yes, Mr. Myers.
See, and I'm trying to get back to this thing with the law library, because the jail sent me here with specific instructions today to come back with, because she's claiming that I have access to the tablet and if I want something printed and all this. And the jail said that's not true, okay? The jail said that he hasn't given any orders, and I got Specialist Zarate, badge number 7926. He says the jail says there's no court orders in place for me to have access to the law library. And he said if I want to have access, I must come back with a court order in my hand, signed by the judge, saying she's claiming I have access to all that. The jail would tell you they don't.
Okay, so let's set that on 10-6. Let's set that
I need
on
to
Monday.
work on my case.
We're gonna
So
set
right
that
now
on
I've been
Monday.
in jail. I've had 368 hours available to work on my case, and I've been able to work on it 0, because reading the statute on the tablet doesn't prepare. I don't have the disclosure, and we have to go over hours of videos. And so how can Parvin sit there for hours at the jail when he's got other cases?
Okay.
So they're just trying to this is all a big tactical advantage game thing. They're trying to
Let me
game.
explain
Yeah,
that.
hold on, please. In CR 2025 1060, court will set a hearing with
Talking about
regards
1060.
to defendants' access to
I need
legal
something to take to the
resources
jail in my hand.
at that time. Okay, I'm not going to set it. Yes.
Yeah, I just wanted to know, so is he saying that Mr. Parvin has not provided him his
No.
disclosure?
Don't say that.
I'm talking about
I-
you not providing my disclosure in this. What is the case number?
I've spent hours showing him
1060.
videos.
That's-
all right.
He wants copies 24/7.
That's
He
not
doesn't want-
true.
Monday.
That's what
Can
you
I
want.
fire him right now?
Okay, fine. I thought
Thank
you
you,
were
Ms. Stiles, Mr. Parvin, Mr. Myers.
I can't have my
Monday,
lawyer
3 o'clock.
lying in
Okay,
court.
fine. Then I'm wrong. I'm sorry. I misspoke.
All right. I didn't even hear it. I'm looking at the dates, Mr. Myers.
Well, I mean, this is important. This is the only chance to make a record. She's claiming that I have access to disclosure. Then, how do I go back? I want to go back to when I go back to the jail today. I want to work on my case. How can I pull out the disclosure and work on my case? Oh, you mean I gotta have Parvin come down there when he has time? That's not effective pro se representation. And I'm supposed to go down to. She said in the last court they were going to provide a laptop to go over this stuff. And furthermore, I am going to file a motion, and I need access to my jail calls so I can listen to them, where I'm going to catch them violating attorney-client privilege. And so how am I going to sit at the jail and listen to my jail calls?
Thank you, Mr. Myers. Mr. Myers, it's going to be heard on Monday, okay? Thank you,
I
sir.
just want one more thing, and I apologize. So what I meant is
Counsel.
he wants copies of CDs, and he wants a laptop with him, because I can get a laptop. They'll give me one to show him anytime. But obviously once I leave, he no longer has access to
That's
it. I just want that was
correct.
dispute. Mr.
Yes,
Myers
that's
is
what I'm
correct.
trying to say.
I apologize for misspeaking if I,
That's
That
what I'm trying
makes
to say
sense.
is, like, when he's not there, that's just, I'm sucking my thumb.
I get it. Thank you, Mr. Myers. Thank you, Mr. Parvin. Thank you, Ms. Stiles. Thank you. State of Arizona versus
Is it all in the email what you need? I just want to make sure. Anything else?
State of Arizona versus
All in the email.
what is it? Urquidez. Oscar Urquidez, CR 2024-1148. Time set for initial appearance on a warrant. Parties announced.
John Robert Granger for the state.
Accidentally muted it.
Morning, Mr. Urquidez. Mr. Urquidez failed to show to his sentencing.
Oh, shit. Unfortunately, I was clicking over and I accidentally muted right at the time that they were setting the time. So I'm not sure what time, but it will be Monday. The original time was set for 4, but then they were discussing how that wouldn't be enough time. So It might be earlier, I'm just not quite sure. I'll be checking on the website the day of. The way I find the hearings for that is you can go to this website, which is https://publichearings.sc.pima.gov. And then you can see the times here. Wow, that went on for a long time. It started, I started the stream a little bit before 11 a.m. my time, and here we are at 12:17. So it did take a while for them to call him. I'll be deleting all my previous lives where it didn't contain his court hearing because those titles aren't correct. But yeah, I'll be covering the next one as well. Thank you for watching, and okay.